What's up, everyone? Welcome back to the channel. Let's talk about it. In this channel, I talk about my personal experience with courtroom corruption, police brutality, and more. If you guys see my videos on my channel, and if you guys like my content, please hit that subscribe button, hit that like button, and share my videos. I appreciate everyone's support. This isn't a typical channel, and to be honest, I never anticipated ever sharing my life in this type of fashion or experiencing the things I did experience. I've got nothing to gain to mislead, lie, or bash anyone. My videos are always factual. You can see in my previous videos, I try to reference as many exhibits, facts, evidence as possible because, again, I got nothing to gain to lie or mislead. The judicial abuse that I've endured is it's enough to break the average man, and it's only right that since I'm being silenced, that I get these events out. So again, thank you everyone that's here checking out this video. This video, I'm going to be sharing my personal experience with the Kitchener-Waterloo Small Claims Court. The issues I have with this small claims matter is you guys are not going to believe it. If I was to tell you guys, about these things, you just wouldn't believe me. So that's why I need to do these videos. I need to protect myself. I feel like I've been targeted. There's an obvious pattern of judicial abuse that I've endured in this Kitchener-Waterloo courthouse. I wish I didn't have to go through that. And to be honest, I wish I didn't have to make these videos, but I feel like I need to make these videos to protect myself. Just like the family court in Kitchener, I went to the Kitchener-Waterloo. I dealt with Kitchener-Waterloo courthouse. I was unlawfully dragged into the family court matter, which I lost. They trashed my life with that family court case. Then my ex and her lawyer, John David Ekpyong, the shit they got away with family court is. It's insane what they got away with, what they did, what these judges aided and abetted. But the Superior Court, that vexatious litigant application, they robbed me in that. They forced me to go to this hearing, this motion, this lawyer, hundreds, dozens and dozens and dozens of rules and laws this lawyer blatantly ignored, even brought up these violations to the judges. They did nothing about it. Two judges, alone Justice Gibson and Justice Ian Smith, entertained. They entertained, 160 plus 55,000. These two judges alone entertained $215,000 in fraudulent bills. Collectively, between the two of these judges, ordered me to pay $95,000. This lawyer, John David Ekpyong, and his client admitted on an affidavit for this family court case. They paid $7,000. For that, my appeal that I had in the divisional court, they admitted to paying $11,000. They asked for $55,000 in that, but they also asked for $55,000 in this vexatious litigant application, and they got $35,000. Imagine that. They got rewarded for perjury and submitted fraudulent documents that I can prove as the facts. I think it all comes back to that trial judge at the family court case who straight up lied on his endorsement. Said I called the applicant, emailed her, I breached with temper restraining, I was not a tenant. None of these things happened. I will be getting into a separate video focusing on the comments this judge made on his endorsements. Calling me a common law spouse. I was never married with her, which is a spouse. I was never common law, which is 3 years continuous, living with someone. I never lived with this woman, period. This video is going to be about the small claims dealings I had with this court and the issues with the court staff. At one point, they ignored me for 3 months. They allowed this lawyer on a second assessment hearing to file a motion to set aside a default. Less than 24 hours for my second assessment hearing, and they slithered on through. And I'm going to get into all the details of this case. It's incredible. It's incredible the judicial abuse I went through. It is incredible that I'm still somehow surviving and standing. I'm on my last leg, let's be honest. Credit score went from 800 to 540. This lawyer, John David Ekping, refuses to let me make any payments. My bank accounts have been frozen for almost 17 months. Imagine that. I've got emails, like I want a dozen emails trying to make payments. They refuse. Still to this day, I do not know how, where, when to make payments. There's been no talk about it. I've got an email offering this lawyer $5,000. He refused it. This is all about pain and suffer. John David Ekping from Nigeria, Africa, wants to inflict so much pain and suffering on my life. Daniel Lee Dobson. And it's just insane. And these judges and these court staff, these prosecutors, the deputy judges, all allowed this lawyer, who I'm convinced got his license out of a cereal box, to destroy my finances, destroy my mental health. And, that's pretty much the short version of this story. I've got the long version of this story, 18 pages. I could see the dip right there, the retention dip just go down. But I'm gonna try to get through this hopefully relatively soon. I'm gonna try for 20 minutes, 30 minutes. This is the longest written video preparation I've had to do. I've never written out 18 pages. This is what I do before every video. You know what I mean? I do a rough draft, what I'm going to talk about, and then I rewrite it. I rewrite that. There's some things that I'm going to get into that I don't even need to. I don't even need this, to be honest. If I was having a conversation with somebody, I would know exactly what to answer. My answers never change. Okay? Eventually, I'm going to need to speak to a lawyer. But right now I can't. I'm struggling to do that. This judicial abuse, this crap that they put me through, this Kitchener-Waterloo courthouse, is got to be Canada's most corrupted family court case in Canadian history. I'm convinced. I don't think there's any other individual who's gone to that Kitchener-Waterloo courthouse who has endured this much judicial abuse, this much court staff misconduct. I've got about 10 documents that this lawyer, unsigned, uncommissioned, not like this court has accepted everything. Left applications at my doorstep, filing late on New Year's Eve. Half of his material should have never been accepted. These prosecutors and these deputy judges. Okay. So yeah, I'm gonna get into this video right now. This is gonna be another monster video. And you know what I mean? I hope you guys can ride along with me and just hear me out on this abuse I endured in the Kitchener-Waterloo Small Claims Courthouse before 2 deputy judges, and I will get into a third one. Dealing with the Kitchener-Waterloo Courthouse, Family Court, Superior Court, Criminal Court, and now a Small Claims Court, there's an obvious and continuous pattern of judicial abuse towards me. I am convinced Kitchener-Waterloo's local senior judge, Justice Michael Gibson, has influenced every judge, court staff, deputy judges, and prosecutors with notes left about me or possibly communicated with these individuals in and out of the chambers. I have compelling evidence to back up everything I ever said on my channel and everything I'm about to say in this video. I have nothing to gain to mislead, lie, or bash anyone. I made this channel to share the truth about the judicial abuse, police brutality, the public servant abuse that they are doing everything in their power to silence me. This video is about judicial abuse and the unfair handling of 2 small claim cases in the Kitchener-Waterloo Court, Small Claims Court. 2 cases, SC-23-1046, that was the defamation and slander lawsuit I brought against my ex, and the SC-24- 419 property damage during the illegal eviction, which John David Ekping instructed my ex, his client, to illegally evict me through an email, and they were both sued on that. The Kitchener-Waterloo Small Claims Court robbed me again, this time of $35,000, of a $35,000 assessment hearing. I dealt with 2 deputy judges, James Marinette and Deputy Judge Paul Familia, and also Deputy Judge Raquel Green. Deputy Judge Paul Familia was the worst and most fair out of all of them. He allowed a settlement conference to run without me. He enabled John David Ekping-Young to lie and obstruct the courts, accepted a motion to set aside a default that was filed 24 hours before a rescheduled assessment hearing. He put on hold because he had to wait for Justin Ian Smith's endorsement for that vexatious litigant case, which is case CV-24-1824. These cases are on Canley. So I'll get into the first case here. This is the 23-1046 defamation slander case. On February 20th, 2024, okay, a settlement conference was heard with John David Ekping-Young. He never served me or notified me about this conference. And he blatantly lied to Deputy Paul Familia and said I refused to show up to my case and dismissed it and ordered me to pay $1,500 plus cost. I've got his endorsement from that day, and I want to read some of the things. I will be putting it up on the screen. The plaintiff and the defendant had been involved in a relationship that ended, and the plaintiff left the defendant's home. Subsequently, the defendant brought proceedings to obtain a restraining order from the Superior Court of Ontario. Subsequently, the plaintiff brought additional motions and also commenced litigation at the Landlord-Tenant Board. Yeah, he goes on. He runs me down in this. Given the above, I'll read it to you guys. I don't need to say everything. I'm just trying to see what here. Oh, the plaintiff has not served any notice as required in the Libel and Slander Act. Furthermore, there was no publication of any of the alleged defamation statements as the evidence given under oath. Let me see here. Okay, I'm going to just, given the above, the court is satisfied that the plaintiff, me's claim has no merit and that itself is frivolous and vexatious. The court makes the order pursuant to the general power as set out in Rule 12.2, Sub-Rule 3. And this court further orders that the claim is on its face of inflammatory, a waste of time, a nuisance, an abuse of the court's process. It's simply clear from the above materials filed in this court and the defendant's affidavit in support that the plaintiff's only intention to bring this claim is to harass, vex the defendant. As such, the court orders that the procedure set out in Rule 12.2, Sub-Rule 4 is not to apply. This would only apply to the opportunity of the plaintiff to carry this would only present another opportunity to the plaintiff to carry his inappropriate behavior towards the defendant. Orders me to pay $1,500 plus cost. See, this is where the crap started with this deputy judge, okay? First of all, John David Ekping-Young straight up lied to this deputy judge, told him that he served me and I've refused to show up. He never served me, and it was confirmed in court. He lied to this deputy judge. Reading this is absolute crap. This woman ran me down in multiple courts. This case here, I had all the exhibits telling the courts I was stalking her while she visited in Burlington one day, which was bullshit. Told the courts I smuggled cocaine to the Bahamas, which was bullshit. Said I was dealing cocaine to her neighbors, which was bullshit. She went on a bunch of friggin' lies. This woman lied so many times to get to... She even said at one point, I called her 20 times one day. It was private calls. She later on admitted she never answered those calls or provided my calls. This woman, and especially this lawyer, went to any length to try to win. And it's just of lies, you know. Saying that it's a waste of time. It's just reading this, you know, I don't even want to read it, you know, because the things he's saying in here, you know, it's just, I just obviously don't agree with it, and it's not true. You know, trying to say it's vexatious. It's, you know what's vexatious is when a lawyer has to lie to a deputy judge. And then this deputy judge ignorantly does nothing about it when I brought it to his attention the following year. And I brought it to another deputy judge's attention too. You want to talk about vexatious and abuse of the court's process? When you got lawyers getting their license out of cereal boxes, okay, and doing this crap and getting away with it, The judge's behavior is vexatious, and that's just the truth, okay? You want to make these comments about me when you ran a settlement conference that I was not properly served, okay? All right, enough with the bantering. I got to get into this, but I'm just... I went before this deputy judge again, and it was the same crap he put me through, and I'll get into that. John David Ekping committed perjury and obstructed justice. When I brought this up to Deputy Judge James Marnett and Deputy Judge Paul Familia, they did absolutely nothing and supported this criminal and unethical conduct. Pinhead John David Ekping emailed me the following day and told me I lost the case because I refused to show up. Okay. I'm going to put these emails on the screen. February 21st, 2024, day after this settlement conference. Check the rules of civil procedure. Remember, you refused to show up in court yesterday, and the court dismissed your claim, your small claims court action, and awarded more than $1,700 costs against you. I said, I did not refuse to show up to court. I was never told the date. What are you talking about? The date was sent to you and I. The court copied you and me. You cannot win that argument that the court did not email you, because I see your email address in one of the court sent me. The one the court sent me. Thank God it was sent by the court. If it was for me, you would have said I did not send it to you. This is what a fucking deranged, unhinged, fucking peanut brain lawyer John David Ekping is, okay? Because you see this shit he's sending me, the gaslighting he does. I'm going to show you guys the email right now that I had to reach out to this court. I'm not done reading this correspondence yet, but I had to reach out to the court. And that's when I talked to someone there, and they sent me the email to show me that they didn't include me in the email. All this lawyer does is talk out of his ass and flip a coin for what decisions to make. And this is the crap these judges have been supporting. Okay? I said, I did not refuse to show up to court. I was never told the date. What are you talking about? The date was sent to you and I. The court copied me and you. You cannot win that argument. The court did not email you because I see your email address in the one the court sent me. Thank God it was sent by the court. If it was me, you would have said I did not send it. Sorry, I just read that. I said, you are responsible for sending me the motion and the date. It is not the responsibility of the court to tell me. If you're viewing the email, send me a copy. Okay? And then I'm looking at the email right here. That was sent to John David Ekping on January the 16th, 2024, and it's notifying him about his notice of motion. It wasn't a settlement conference, it was a notice of motion. So this pinhead, John David Ekping, talking out of his ass, sitting there saying, I'm looking at the email right now. No, he wasn't. He was probably playing hangman with his nonsense, okay? Because that's what he's doing. He's hanging himself, doing this shit. You see the emails, him telling me he gave me enough rope to hang myself. This is how this lawyer operates. He's sick in the head. Okay, so that happened. Okay, I'll share that with you guys. I had to file an emergency motion to set aside order on motion with the Kitchener-Waterloo Small Claims Court. And on March 12th, 2024, at the motion to set aside an order on motion was scheduled and heard before Deputy Judge James Marnett. When I brought up to Deputy Judge James Marnett's attention about how John David Ekping lied to the courts, this deputy judge said he didn't care and we weren't here for that. This deputy judge was ready to finish the motion and not let me speak. The raised hand icon was visual on Zoom, and he ignored me. He was about to shut down this whole motion without letting me talk. The person who filed it, the person who took a day off of work to respond to this fucking bullshit of this guy filing motions and not serving people and lying to deputy judges. And all this has been brought up to these senior judges, these prosecutors, the Law Society. They all collectively do nothing about it. They're encouraging this behavior by not doing anything about it. I missed work that day, losing close to $800. I requested for costs, and this deputy judge said the best he could do was $100. I was able to convince him to bump it up to $200. I have never seen $1 of those court costs. Let's get that endorsement that he wrote. Yeah, March 12th, 2024. Deputy Judge James Marnett. He's got 6 items here. Um, okay. February 20, 2024, a motion was heard by a judge of this court. Mr. Dobson did not attend. The result was that the claim was dismissed with cost to the defendant. Mr. Dobson was never served Mr. Ekping-Young with the Zoom meeting ID or password for that hearing. For that reason alone, the order, February 2024, must be set aside. While there is no rule of this court permitting to set aside an order made on a motion, I rule an analogy of Rule 17.04, 17.01, sub Rule 4, that if I have jurisdiction to set aside a trial judgment against a party who failed to appear to a trial, the same power ought to exist for orders made on a motion. This is not an appeal order of February 20th, and I say nothing about the merits of that motion. I find that special circumstances exist for the purpose of Rule 15.07, and that the respondent to this motion ought to have consented to knowing that the applicant was never properly served. Therefore, it is ordered, the order of the court dated February 20th, 2024, set aside for a new day of the hearing of the motion may be obtained by the trial coordinator. The defendant respondent shall pay the cost of the motion fixed at $200. So, preparing for this motion, I had to prove to this deputy judge that I was never served. Like I said, this pinhead, John David Ekping-Young, was caught lying red-handed to these deputy judges. The deputy crown attorney in that Kitchener-Waterloo courthouse, Armin Sethi, was fully aware of this, and she ordered her junior assistant crown attorney, Wilson Lim, to dismiss criminal charges. And it's just in every court, they do this to me. So here you go. You got proof that this lawyer straight up was caught lying to judges. What did they do? Nothing. Absolutely nothing. Fast forward to June 17th, 2024. We get before Deputy Judge Raquel Green for a settlement conference case. I want to drop this case. I wanted to drop this case. I started the paperwork, but John David Ekping-Young, I wanted to drop this case, I stated, but John David Ekping-Young and his client refused to let me do so. John David Ekping-Young and his client request for $5,000 to allow me to drop the case. John David Ekping-Young wrote a 2-page affidavit which makes this request retarded and abusive. John David Ekping-Young and his client go down to $1,500. I am not agreeing to pay these two crooks any money to allow me to drop my own case. Deputy Raquel Green chimes in and says how the lawyer took his time to write his materials and it justifies the $5,000 or $8,000. I think they were asking for $8,000. I had to double check, but she starts, like I said, chiming in, and the guy wrote a 2-page affidavit, and she's trying to chime in and justify that asking for $8,000 is fair because I'm a self-represented litigant, and they just love to abuse me in this courtroom. And I'll have to get in a video of every event of the abuse I've endured, because it's only in the public's best interest to know about this judicial abuse, this courtroom corruption, this courtroom abuse. Because honestly, I'm just sharing this with you guys because you guys could find yourself in this type of hot water situation, So you guys got to be very mindful. It's the sole reason really I'm doing this channel is to share my experiences honestly, truthfully. And for you guys, everyone that's watching this, you got to be mindful. You got to avoid this psychotic conversations as best as you can. Even when you think you have a grand slam or some type of game-winning alley-oop, and if you can avoid it, you avoid it. You don't take the chance to try to roll dice in this court. First of all, I don't think John David Ekping-Young's client paid him any money for this case, and that's why we need proof of payment. Asking for $8,000, okay. Secondly, these two now have the impression they can get away with abusing the courts because 2 weeks earlier, Justice Michael Gibson granted them $60,000 after he entertained a fraudulent bill of $160,000 when the same judge read John David Ekping-Young's affidavit admitting his client only paid $7,000 to the family court case. So these two crooks now have the impression they can get away with abusing the courts. They just got away with submitting a fraudulent bill of $160,000. Why not ask for $8,000 for a 2-page defense affidavit? So they tried that. This deputy judge, Raquel Green, will not let me drop the case and states in her endorsement The plaintiff is granted to set his matter down for a trial. I never requested for a trial. This is how crazy and ridiculous this courthouse is getting. This is nothing but a friggin' circus with these things happening to me. I need to get the audio recordings so you guys can hear, which they won't even give it to me. That audio recording lady in that courthouse won't even answer my emails because she's been instructed not to talk to me from the judges and the court staff, which is a public service, more corruption. You'll hear in those audio recordings. The media, I need someone from the media to order these audio recordings. Get them all. Start a whole new channel doing commentary on these things. You'll hear in the audio recordings that I never requested for a trial. I wanted to get rid of it. These two crooks won't let me drop it unless I give into more extortion. So that's how this case ended. This was the last appearance for that case. This deputy judge refused to let me drop the case and said, I'm granted to set the matter down for trial. I never asked for a trial. You'll hear in the audio recordings, not once it came out of my mouth. Now I'm going to get into the property damage case where I was robbed by this court. Straight up, robbed by this court, robbed by the other courts. And when I say robbed, I'm going to get into everything. That they robbed me by skipping out on 2 assessment hearings because of this vexatious litigant application. Mind you, my case was this small claims court, this damages was filed way before that vexatious litigant application. These two were noted in default, never filed a defense, way before that vexatious litigant application. So right there alone, that supports the corruption, the allegations of corruption that I'm up against with this courthouse. And it's just simple. It's just simple. This courthouse can easily fix the damages they did. This courthouse, this lawyer, my ex, destroyed my finances. They refused to allow me to pay any money. 16 months of fraudulent documents. And this all stems from the family court case that was rigged, I was unlawfully dragged into, and Justice Michael Gibson, local senior judge, entertained a fraudulent court cost submission. And he created 2 monsters, thinking they can ask for whatever they want. Asking for $20,000 for 5 affidavits of their 6 pages each, copy and pasted. Come on. Small claims case 24-419. This was the case that confirmed the obvious and continuous pattern of judicial abuse. John David Ekping-Young and his client got sued for damaging tens of thousands of dollars of my property in March of 2022, where John David Ekping-Young acted as a witness and instructed his client to illegally evict me in the peak of COVID in -15 weather. And the following day was a blizzard I've never seen like I have ever in the KW Cambridge area. John David Ekping-Young and his client, and this is the shit you guys are not going to believe. What I'm about to get into, you guys just are not going to believe this. John David Ekping-Young and his client never filed a defense. They got noted in default. Then filed a motion to set aside noted in default motion to the court. Court staff accepts this motion on March 24, 2025. Same day it's filed. The same day it's filed. They ignored me for 2-3 months, my paralegal for 2-3 months. My second assessment hearing is scheduled for March 26, 2025. The first assessment hearing was done on January 21st, 2025, before Deputy Judge James Marnett, who said he couldn't make a decision because my paralegal, Sharina Garner, did not put an amount down on her paperwork in the. Well, to be honest, if this deputy judge bothered to take 5 to 10 minutes to look at my original application, he would have known exactly the damages caused and the amount of money I was asking for. And he didn't do that. He just should probably read his. I want to read his endorsement from that day, from March 21st. James Marnett, who was dealing with a motion for default judgment on January 1st, 2025. And this is somewhere where no one attends. It's just up to this deputy judge. He's got 4 points here. A hearing is required because the affidavit filed does not address the amount of damages, which it is only purpose. It is not appropriate for legal counsel, for legal representation to make an affidavit to prove damages. it is doubtful that the claim discloses a cause of action against either defendant, and it does not. And if it does not, that's not something that can be remedied on a motion for default judgment. So now we're in January 2025. When I read this, my intuition tells me that there's been direction from a senior judge in that courthouse. Think about it, right? An affidavit does not address the amount of damages, which she didn't do. I'm going to get into that. That whole thing she wrote was sloppy. And she wrote it after she quit on me. And I'll get into all of that. Right? Look at the comments this deputy judge is making. You know, I just don't agree with them. You should see all the damages I had. Okay, the whole basement rental unit was emptied and put on the front lawn. There was pictures of all the shit that got damaged. All my memorabilia. They fucking trashed all my property. And this fucking deputy judge, part of my language, this deputy judge is going to sit there and ignorantly say, it's doubtful that the claim discloses cause of action. It was a fucking illegal eviction. Okay, that I went to the landlord-tenant board, that they too allowed all this shit that fly that you got. I put in another video. You can see I'm a little bit frustrated because this has been nothing but crap dealing with this court, and then the obvious pattern of this judicial abuse from these part-time deputy judges. At that time, they were part-time deputy judges, and this deputy judge he can't even take 5 minutes and look at my plaintiff application and look at all the damages. He's going to sit there and say, it's doubtful. It is doubtful the claim discloses cause of action. This tells me this Deputy Judge James Marnett, didn't even look at my application. Why is he solely going off of that? That's fine. That's what they're there for. A motion for default judgment. This fucking bonehead, John David Ekping-Young, never filed a defense. Got noted in default. And then this deputy judge wants to play these games with me, like they all have played games with me, and he's going to adjourn it. What do? They adjourn it just before, they adjourn it 60 days later, right? That's what they do. So, yeah, this one's going to be good. We're going to get into this one here. If the deputy judge bothered to look at my application, he would have known what I was asking for instead of saying, John David Ekping-Young and his client never filed a defense. That's how ignorant and incompetent this lawyer is. Or did someone from the court tell him not to bother filing a defense? Because this happened before. I filed a motion in the civil court. They didn't even show up. They didn't file the materials. And the judge kicked me out that day. Justice Reed, the Kitchener-Waterloo courthouse. So, they didn't file no materials then. I got no cost. They did this before at the trial I had for that divisional court when they had 60 days to respond. They filed it 14 months later, 12 months later, and they accepted it. Told me that it wasn't prejudice. So that whole thing was that they never filed their materials on time for that divisional court appeal. I filed a motion. That's when he served me on New Year's at 8 o'clock. He was way late. And we went before Justice Reed in February, and I asked him to strike down the motion because they did not file their materials on time. And I referenced the laws, the rules, the procedural rules. This judge wasn't having it, obviously because of the notes. There's this pattern of this judicial abuse. And one thing that comes to my mind that I actually heard David Goggins say one time was that, in these type of situations, when you got these haters, when you got these people trying to go for your neck, they want blood. They try to build it up and they try to say, that person's crazy. Oh yeah, look at him making these claims. Well, I'll tell you now, all these claims are factual. I got evidence, I got facts. The rules, what was it, 15, 16 rules collectively blatantly ignored by these judges, court staff. So no, I'm not crazy. I'm pissed off that these individuals, these public servants, are so bold and so comfortable to try and get away with this from me. So no, I'm not crazy. I'm sharing these events in my life. So you got to be careful when you're doing these things and you're challenging people. They will try to do that. They will try to say, Oh, look, he's filed complaints. Oh, look, he's losing. Oh, he's mad. He's going to social media. And then they'll all gang up on you. And they'll try to label you things that you're not, like a vexatious litigant, like they did to me, and other crap. So you got to be mindful of that too. So yeah, he doesn't file a defense. John David Ekpion gets noted in default. This lawyer, these deputy judges, did not abide by the rules of the small claims at times. And the most important rules that they collectively blatantly ignored are Rule 9, a defense. 9.01, a defendant who wishes to dispute a plaintiff's claim, shall serve on every other party a defense form 9A, and B, file the defense with proof of service with the clerk. That was never done. We know that. 11A, default proceedings. Rule 11, default proceedings. Noting defendant in default, 11.01 subrule 1. If a defendant to a plaintiff's claim or defendant's claim fails to file a defense to all or part of the claim within the prescribed time, which is 20 days, the clerk may note the defendant in default on filing a request to note the defendant in default, which may be made in Form 9B. Well, I did that. They got noted in default. Assessment hearing. 11.03 subrule 4. If an assessment hearing is to be held under Clause 2B or 3B, the clerk shall fix a date for the hearing and send notice of the hearing to the plaintiff, and the assessment hearing shall proceed as a trial in accordance with Rule 17. I got screwed over because Deputy Judge Familia, Deputy Judge Marnette want to play games and adjourn assessment hearings with their judicial abuse, because that's all they did. They could have ran those assessment hearings, but there's got to be some instructions. Why are they disregarding these rules? And I'm confident that either have read notes from previous judges or have been verbally told by senior judges in that court to handle the proceedings the way they did. 4 different courts in the Kitchener-Waterloo Courthouse: Family, Civil, Small Claims Court, and Criminal. Did the same crap to me at every proceeding. They hung me in the family court. They hung me in the Superior Court. And I'm pretty sure I was labeled the first vexatious litigant in the Kitchener-Waterloo Courthouse after they amended it last year in August. That came into effect in October. So these judges had a heyday with me, dragging me through that vexatious litigant proceeding, an application left at my door, a lawyer who never confirmed his motions. That trial judge, Justice Ian Smith, forced me to represent myself regarding all these issues I brought up to him. Took 40 minutes, went in the chambers, came back, had this long, no, you must proceed, you had time, blah, 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 all this crap again I disagree with. And of course they had none other than Kim Fest, the CEO of Ontario's biggest transcriptionist company out there, personally write this endorsement within days, which I thought was a little bit strange. The same Waterloo Courthouse recordings lady, I got her name here somewhere, who ignored me, has been ignored me from these audio recordings. And again, she's a public servant, denying requests to the public, which I'm pretty sure she's taking instructions from senior members of that courtroom. It's obvious. You're a level 1 employee at the courthouse. Judges are 4 or 5. There's going to be people above you. If she's ignoring me, okay, if this woman is ignoring me and her job is to receive applications for court audio recording requests and she ignores me, okay, it's just fishy. It reeks of abuse, okay? They either hanged me in these cases, they either hanged me in cases or dropped the cases I had against John David Ekpion and his client. This small claims court matters in the criminal court. Rule 2, non-compliance. With the rules effect of non-compliance, 2.01, a failure to comply with these rules, irregularity, and does not render a proceeding or step, document, or order in a proceeding in nullity, and the court may grant all necessary amendments or relief. Okay? What's the point of having rules, laws if judges, deputy judges, court staff, and lawyers are simply not going to abide by them and not uphold the law. They took an oath that they would do. John David Ekping Young and his client were served around July 2024. John David Ekping Young was noted in default on November 7th, 2024. His client was noted in default October 18th, 2024. The court staff ignored my paralegal for almost 3 months. Then they ignored me for 2.5 months. The court staff refused to answer calls, return voicemails, or respond to emails. Being fed up of being ignored, I drove to the Kitchener-Waterloo courthouse in winter of 2025. Would have been January, February, I guess, 2025. I went up to the court counter, taking a number and waiting. I speak to a middle-aged man who works there, and I ask him why is no one answering the phone, returning calls, or responding to emails. I'm calling the number to the Small Claims Court office, and I can hear the phone ringing. I asked the man, which phone is this call going to? He walks over to his desk and answers the phone. Now I'm talking to him on the phone. He walks back over and tells me senior court staff upstairs told staff to not answer the phone and rather respond to emails. This was what he said. That's when I asked to speak to Carrie Rice, supervisor of court operations. I eventually spoke with Miss Rice, and she gave me nothing but excuses for this poor, unacceptable service. And also this court staff ignored me for 2 months. I wouldn't be surprised if she was in on the loop with this court ignoring my paralegal for 3 months, and then they ignored me for 2 months. Okay, I have the emails. I can prove they were ignoring me, and I will be sharing that in this video. I got nowhere with her that day. I got nowhere with Carrie Rice that day. This is the same supervisor who told me in an email she leaves unrelated emails on my file, which other court staff members have access to these additional unrelated materials. This court supervisor court operations told me in an email, and I'll share that they've been screwing me around for years with this courthouse. The court staff rejecting dozens and dozens of my materials when there's nothing wrong with it. In fact, the family court refusing my materials. This supervisor was the one who accepted 15 or 16 of my filings that were rejected that I never had to make changes to. And I believe that was Robin, and I have emails. It was that court staff, Robin. I got nowhere with her. So yeah, mind you, this is the court operations supervisor who told me they leave unrelated emails, which I imagine eventually get into the hands of the judges, which I am convinced judges do the same thing, and they leave their personal comments about individuals involved in matters on their file so the next judge can be influenced by a previous judge's notes. Let's not forget, I was unlawfully dragged into family court. The trial judge, local senior judge, Justice Michael Gibson, straight up lied on his endorsement. This judge lied on his endorsement. He said, I called the applicant, I emailed her, I breached my temporary restraining order. I was not a tenant. This is lies. Never called her, never emailed her. I did not breach my temporary restraining order, and I was a tenant. She withheld the police report that she wrote to the Waterloo Region Police, admitting I was renting her basement. She withheld a landlord-tenant eviction application where she applied to have me evicted. Okay? This judge called me a common law spouse. Okay? I was never married with this woman. I was never a spouse. He said we were common law. Ontario, legally, you have to live with someone continuously for 3 years to be considered common law. I never lived with this woman ever. This judge said in his endorsement, he called me rigorous. He called me a scorched earth litigant. He said I had ominous ad attacks on the lawyer. This judge made all these bogus comments about me, provide all this misleading, intentional, contradictive information on his endorsements on Can Lee that never happened. This is the problem of everything. This family court trial judge, this is what he did to me. Okay? He ruined my life. He destroyed my finances because simply he did not like me. He listened to this audio recording at the family court trial. It was a 50-minute conversation. My ex called me upstairs. About 9-10 minutes into the call, she starts, like, she's provoking me leading up to 8, 9, 10 minutes, like talking shit about me. When am I going to move? Or everything was fine and simple. I'm telling her I'm trying to move. Most of my shit's packed up. That's when she provoked me around the 9th or 10th minute. She hit record. And she recorded me for about 3 to 4 minutes of going off. This judge accepted that, a partially recorded recording. Most judges in Ontario do not accept partial recordings. This judge did. And then I wrote this judge a letter. I'm standing ground that this judge made his decision off of that. The audio recordings that he should never accepted, that I didn't know was being recorded, which is fine as long as one person knows. You can't, it's not a charge, because if I ever get charged for my Ekman Young calls, then she did it too. And I wouldn't be surprised. They're probably on there ready to pounce on me for going public and speaking about this stuff and exposing this stuff. And I'm confident about the things I'm saying, and I can back it up with evidence. And again, I wouldn't be doing these things if the judges, these courts and the judges just wouldn't keep hammering the abuse. Just keep hammering the abuse. Why don't you guys stop the abuse? Why don't, have you dug yourself such a hole so deep that you can't get out, that you have to keep inflicting damage? I think so, right? They've dug themselves such a deep hole of judicial abuse and misconduct, what you can't get out. So you keep inflicting as much damage as you can before time runs out. And this is exactly what John David Ekman is doing while he's being prosecuted by the Law Society Tribunal for this shit. After I was done, now here we go. Now this is where it's going to take a little turn here with this Kitchener-Waterloo courthouse and these staff members abusing their powers and abusing me. After I was done speaking with Kerry Rice and getting absolutely nowhere, I decided I'm going to go up to the trial coordinator's office and try to figure out who is the individual who scheduled the family court trial without that trial schedule endorsement form. They're up on the level 5, floor 6. I went up to the top floor where the trial coordinator's office is. I spoke with a lady who didn't have the answers to my question. So I asked for a person who was in charge. That's when Sloane French came to the window, and I mentioned that my family court case was scheduled for a trial without the trial schedule endorsement form. And she said, Justice Tweedy said to schedule that trial. I mentioned Rule 17, Sub-Rule 11 of the Family Law Rule that parties, not judges, must fill out, serve, and file their trial schedule endorsement form before any trial is ever scheduled. That was never done. This public servant, Sloane French, this trial coordinator, who I would guess has been working for the court for 10 years, should know this. And this court staff turned a blind eye to the law as well, because she took instructions from this Justice Martha Ann Tweedy, who still it needs to be investigated for the things she did on that November 2023, which she hasn't. And I'll be getting to a video to filing complaints with the Canadian Judicial Council work, and the short answer is no, it doesn't, because all this crap started from Justice Martha Ann Tweedy. So that's when Sloane French came to the window, and I mentioned that my family court case was scheduled for a trial without the trial schedule endorsement form. And she said, Justice Tweedy said to schedule the trial. I mentioned the rule. She began giving me attitude, and she screamed, "Security!" And I was shocked that she did that, because it wasn't like I was raising my voice. I wasn't name calling. I wasn't being threatening. I'm there for service. I'm trying to get an explanation to why this trial was scheduled without this form. And she kind of gave me the answer, but it wasn't really all the information. So Justice Tweedy, again, bent more rules and instructed the trial coordinator's office to schedule a trial without the main form, the only form that is required. And then, so she screamed security. And I asked her if she wanted me to leave. She said yes. Shortly after, security guards came in, and then the Waterloo Region Police came in. They were all in the office speaking. So I went back into the office because I was in the hallway. She had asked me to leave. I went back into the trial coordinator's office to make sure that Sloane French wasn't lying. This woman was unprofessional and out of line. There was no need to scream security as if I was a threat. Then police followed me throughout the courthouse. Now I wanted to file a complaint against this woman. At this time, I did not know her name. I went to the first floor and spoke with another young female supervisor like Carrie Rice. They seem to be 25 to 30, and these are the court operations supervisors, which makes you kind of wonder. There's not more senior people, and that they're giving these young adults who've been with the courthouse a couple of years. Now they're supervisors. This supervisor, along with Carrie Rice, refused to identify the woman who screamed security. How am I supposed to file a complaint against a court staff member who I don't know their name and the court supervisors refuse to identify? The long-haired blonde supervisor also refused to identify herself and told me to give her my email and my phone number so she could email me the complaint form. I gave her my email, not my phone number. I never heard back from the supervisor. Her name is Geraldine Dubas, another supervisor for court operations. I spoke with Carrie Rice a couple days after and asked again about the lady's name in the trial coordinator's office. How do I file a complaint against someone I don't know their name? I said to Carrie Rice, and she's like, "Don't worry, we'll add her name," she said. I decided to call the trial coordinator's office back and ask for Simone. I think she said this when I first asked to speak to her, and she corrected me and said Salone. I guess that day I went up there where she screamed security. She said her name was, I thought it said her name was Salone because I asked. You got to ask who you're talking to. If you guys don't know that either, any of these call centers, Service Canada, courthouses, you talk to them, before you start the conversation, you get their name. You get their full name, you get their ID number, their ID number, whatever. They ask for your full name because a lot of the times these conversations go sideways, and at the end of the conversation, you're pissed off and they usually hang up on you and you don't remember their name. So a good word of advice is dealing with any of these public servants on the phone, in person, in emails, or on the phone. You ask them to identify themselves and you get that before you start talking. Like now I'm on the phone with Salone French. I called. I'm trying to figure out who this person is because the court won't tell me. I mentioned again about how she scheduled the family court trial without the trial schedule endorsement form, and that's when she got snarky with me and told me to file a complaint against her, and her boss's name was John Hornby, which I did, and he was absolutely useless, John Hornby. I spoke to him on the phone. He said he would look into this situation. He responded a couple weeks later and turned the situation around on me and refused to properly look into it. I found out Salone's last name was French by researching online. She's a part of this group at that courthouse who has bent the rules, ignored the laws, scheduled the trial schedule without the trial schedule endorsement form, which is required by law. I would like to know, how long has this person been working in the trial coordinator's office? 2 years? 1 year? 5 years? 6 months? Why are you taking on a job where you don't know the rules or you are intentionally ignoring them? This person who scheduled the trial is part of sabotaging me in these courts, and she is also part of destroying my finances. I learned some new things that day. Not only do judges, prosecutors, deputy judges disregard the rules against individuals they clearly don't like, but so do the court staff, which some judges instruct them to not play fair and disregard the rules and laws that were sworn to uphold. Like when Justice Martha Ann Tweedy told Salone French to schedule that trial with no trial schedule endorsement form. So that was a shit show I dealt with this court staff. Simply trying to figure out why are they ignoring me. So I had to go up there, and then all this shit unravels. Okay, so I'm going to jump back into this Kitchener Small Claims Small Claims Court mess. So John David Ekping and his client are noted in default in October-November 2024. A motion for default judgment is scheduled and heard on January 21st, 2025 before James Marnett. And that was, I made a note here to read that James Marnett from January. My paralegal's motion affidavit had plenty of flaws. This deputy judge ran it down. But he had the basic materials to make a judgment and not adjourn it. But yeah, this paralegal, Sharina Garner's, her motion, an affidavit, had plenty of flaws. She never put down the dollar amount of damage. This was actually a huge mistake on her. She was a brand new paralegal, so it was either inexperienced, incompetent, or deliberately intentional. Her motion affidavit was dated November 23rd, 2024, which Sharina abruptly quit on me on Monday, November 19th, 2024 at 8:30 a.m., which was strange because I'd hired her in May, June 2024. Finally met her in person on November 7th, 2024. We had a settlement conference the following week, and that was on November 14th. Then she quit on me on the 18th. That small claims case that she quit on me, that was horrible. I met her a week before. I thought everything was good. There was no signs. She was good. There was no issues. And then she did this crap, which I was really surprised and disappointed. And, probably a good reason why you never hire a new lawyer, a new paralegal, because these things can happen. And her reason, she said, I'm going to be honest. This is the reason why she quit on me. Her reason, she said, several of her family members were murdered in the Caribbean, and she was going to live in the mountains for up to 6 months, and she wouldn't have Wi-Fi. This was a bold lie, and there were no reports of these events, she told. In fact, she started working for a new law firm as a paralegal in January 2025. Her sloppy motion and affidavit contributed to ruining that assessment hearing before Deputy Judge James Marnett. I could have easily split those damages with her, but she ruined that and always wondered if she was influenced by someone from outside of the court, from in or outside of the court. A motion for default and assessment hearing is finally rescheduled on March 26, 2025, which again, the court ignored my calls, voicemails, emails. The courts intentionally scheduled this motion of damages assessment after the vexatious litigant motion that was heard on March 21st before Justice Ian Smith, which the vexatious litigant motion should have never been heard because John David Ekping-Young never confirmed his attendance. Justice Ian Smith and several other judges deliberately ignored rules like 37.10.1 Subrule 1A. A party who makes a motion must confirm their attendance. John David Ekping-Young never confirmed any attendances. Me, I confirmed every single fucking attendance in all of those courts. Every single motion that I've scheduled, I filed my attendance. Every single motion this fucking pinhead scheduled, I confirmed my motion. He didn't. And his license needs to be investigated. Whether the Law Society Tribunal is going to do it or not, he needs to be investigated. I am confident he did not get his credentials, honestly. And I'm honestly questioning his citizenship. He is abusing his license and he is abusing real Canadians. This is the crap. And again, this is the crap that the Liberals have allowed to go on for 10, 20 years. Okay? With this immigration shit. You got people coming up here who are coming from a very hard life, all this war and murder, and then they get comfortable with getting paid through Ontario Works and all these other systems, these refugee claims, and then a lot of them are turning around and they're abusing their stay here by, like what John David Ekping-Young is doing to me, these violent protests, okay? You see these protests, threatening police, not getting charged, then you got this convoy friggin' protest. Look at the contrast. The shit that they're allowing. The shit that they're allowing John David Ekping-Young to do. Okay? If a motion must be confirmed and parties must confirm their motion and confirm their attendance. Rule 37.10.1 Subrule 4A, effective failure to confirm a motion shall not be heard. Every motion that this fucking lawyer scheduled, he never filed his attendance for the motion. These senior judges allowed it every single time to protect this fucking family court endorsement. Okay? This is all it is. They cannot let me in. So what do? They bend the rules. They bend the laws. They break the rules. They break the laws to protect themselves. They don't give a shit about some fucking white guy who is a licensed electrician, credit score 800, paying $6,000 a month in fucking taxes, which I can tell you right now is some of these judges, what they make a week. Okay? Justice Gibson, Justice MacArthur, Justice Ian Smith, all senior judges of the Kitchener-Waterloo Courthouse deliberately ignored these rules and many others, and they all allowed his motions to run in that vexatious litigant application. I brought all these rule violations to these judges, and they ignored them every single time. Do you see the pattern of corruption I'm dealing with? So I believe these are malicious handlings of scheduling these motions. It's right there, plain as day. There is no guessing. Oh, is Mr. Dobson, is he a part of Bill C this, B C that? No. Everything is factual and honest. So these guys are going to do whatever it takes to silence me. That's just the honest truth. Okay? John David Ekping-Young files a motion to set aside the default on March 24, 2025. One day before my second assessment hearing, the court accepts it immediately. They ignored me for 2 months, ignored my paralegal for 3 months. They're now accepting this motion to set aside a default in less than 24 fucking hours of my second assessment hearing. The court accepts it immediately. The Kitchener-Waterloo Small Claims Court ignores me and my paralegal for almost 6 months. They can accept John David Ekping-Young's motion less than 24 hours from my assessment hearing. Again, do you see the pattern of corruption? Okay. Got 2 more pages left. We're almost done here. We get before Deputy Judge Paul Familia. The deputy judge that John David Ekping-Young was caught blatantly lying to. When I mentioned this to Deputy Judge Paul Familia, he does absolutely nothing. Deputy Judge Paul Familia accepts John David Ekping-Young's motion and puts my motion for a default for an assessment on hold pending Justice Ian Smith's decision. John David Ekping-Young never filed a defense. He got noted in default. How is this even legal? It's not. It's a violation of the rules in the Small Claims Court. And I know there's a rule in there that there's a little clause that they can accept these motions. It's in there, whatever. They can say they're going to reference that rule. But what about all the other rules? What about all the other rules they ignored, right? Interesting fact. Here we go. About this deputy judge. Interesting fact about Paul Familia. Deputy Judge Paul Familia. He is a chair member on the Discipline Committee on the Bereavement Authority of Authority, Code of Ethics hearing of funeral services professionals. He disciplines people as he's a chair member, but he refused to discipline John David Ekping-Young for committing perjury, obstructing justice before the courts. Instead, Deputy Judge Familia rewards John David Ekping-Young by allowing his motion to set aside noting a default, which the courts accept his motion less than 24 hours notice. This is what the local senior judge of that court is allowing in his court. And I'm convinced he's orchestrated some of these shady events by instructing court staff, deputy judges, and prosecutors to all railroad me. There's a very obvious pattern and continuous pattern of judicial abuse. Okay? And if what do I got to do? Go in a video of every single court case that I did? I've already done it. This is my last video dealing with this court. Okay? You've seen the abuse in family court. You've seen the abuse in the Superior Civil Court. You've seen the abuse in the criminal court, which I haven't really fully gotten into yet. I might get into that, which will be about 5-10 minutes. And then you see the abuse I've endured in this small claims court. Justice Ian Smith finally delivers his endorsement on June 27, 2025, a Friday at 3:30, 98 days later, after he made a dozen statements. 98 days later, he reviewed and labeled me not only a vexatious litigant of his client, but goes above and beyond and also involves John David Ekping-Young, whose name was never on the application. They never requested for that. And this judge goes above and beyond. Why? Because they're fucking protecting this lawyer. He's supposed to be, they know there's this assessment hearing going on. If they label me a vexatious litigant, all of my court proceedings, they become state. and I have to file a motion to request to reopen it. But he only did it for these two. That day before Justice Ian Smith was absolutely fucking bullshit. I was fucking in tears that day. I told him how fucking suicidal I've been over this, all this court shit. My friend was in that court. I told this judge I don't want to get to know my friend because I have suicidal thoughts. This judge did not give two fucking shits about my mental health or the rules that day. Okay? And then what does he do? He labels me a vexatious litigant. Only against these two. I told him about my fucking lawsuit against the police. And what about the shit that happened to my mom if I got to make fucking lawsuits with that? Doesn't do that. Only these two. And a lawyer whose name was never on the application. Okay? Let's not forget. Oh, and this was on Canada Day long weekend. See how they did this to me on my birthday, right? Waited for my birthday, 60 grand. Waiting almost 100 days later. And I'm trying to figure out this assessment hearing, and I can't do anything because I'm waiting for this decision. Canada Day long weekend, 3:30 on a Friday, sends me this fucking shit. Now, and I'll tell you right now, this endorsement was on Canley like that. This court staff keeps fucking crying how they're so backlogged, they're so backed up, short-staffed, this, that, the whole 9 yards. My fucking Canley endorsement, my endorsement was on Canley within fucking minutes after he released it. You're going to tell me they're not fucking taking orders from the fucking senior people in that courthouse? They are. And excuse me for my profanity, okay? I'm passionate about what I'm going through. And again, I'm not sitting here lying. I'm not sitting here threatening people. I'm not providing misleading information. What's the next thing? I can see maybe what's the next thing. You guys, you're going to fucking charge me? They're going to try to charge me, right? And they're going to try to silence me. What, you're going to give me a fucking penitentiary bid? Because I'm sitting here talking about the abuse that all these people did to me? They cannot back up what they did to me with evidence and facts. Okay? They can back it up with fucking bullshit and bullying and piggybacking me. Okay? I've been nothing but respectful to all these proceedings while they did this to me behind closed doors. And how the hell am I supposed to trust any of these attorney generals? Forgive me for saying this, for judges moving forward when they have tainted the integrity, their reputation. These judges have put such a stain, these court staff, deputy judges, okay, they've put such a stain on being impartial, being fair, being honest. This is what they took an oath to do and what they must abide by under the Judges Act, okay, that they're not doing. So, nothing to worry about, okay? It's like, you know, this is what it comes down to. I'm sharing my life. And now I'm getting a little bit more visual with how much this has affected me, considering I'm on the brink of bankruptcy and homelessness, pretty much because of Justice Gibson. This judge destroyed my finances. He gave these people a piece of paper, which is a tool to abuse me, to fucking destroy my life. You want to order me to pay $60,000? At least let me make fucking payments. Don't fucking sit there and block all my bank accounts, ignore 30 fucking emails saying, please let me make payments. And then you let this fucking pinhead, John David Ekping-Young, fucking get away with this shit. You know, you can't be surprised I'm upset. You know, anyone out there that's against me, that I'm litigating against, you want to use this against me? Go for it. Because everything that I said in this video is the truth. And you want to question me on anything? I got it all to back it up. I'm not trying to be arrogant or ignorant. I'm frustrated from the judicial abuse, the court corruption, okay, the police brutality, the public servant abuse. Tens of millions of dollars every year get allocated to these individuals who want to work for the government, and then they demonstrate, they forget they're working for the people who pay them, and they act like they're working for a corporation. Let's not forget the closing arguments. John David Ekping-Young tried to dictate and manipulate Justice Ian Smith. John David Ekping-Young tried to dictate and manipulate Justice Ian Smith to label me a vexatious litigant with filled out court documents that a judge only fills out and request for $15,000 for this vexatious litigant application, which he later asked for $55,000, another fraudulent bill. And I've put it public what my cost and mentioned this to this judge. Again, did absolutely nothing about perjury and submitting fraudulent documents. When John David Ekpyong submitted his costs, he requested for $55,000. Another Superior Court judge, entertains a fraudulent and bogus cost request and orders me to pay $35,000. Ironically enough, that's what John David Ekpyong and his client were supposed to pay me at that trial assessment hearing. This action confirms that corruption is real in the Kitchener-Waterloo courthouse. Judges ignore the rules they were sworn to uphold. Okay. A dozen employees of this courthouse broke the rules, bent the rules, ignored the rules, disrespected the rules, and destroyed my life, destroyed my finances, destroyed my mental health, simply because a senior judge just didn't like me. Okay? And that was that 4-minute audio recording, that partial recording, and that letter I wrote to him. All right? This was bullshit what I went through with this Kitchener-Waterloo Small Claims Court. These court staffs are fucking playing games with me, ignoring me for months. These deputy judges telling me I've given me okay to set down a trial when I never asked for one. Deputy Judge Paul Familia, it was brought into his attention on this March 26th, 25th assessment hearing there that John David Ekpyong lied to him. He didn't do fuck all. Like, they're aiding and abetting these criminal activities. If they fucking go tell them, this is contempt in court. You can fucking go to jail for this, okay? And this is what this pinhead, John David Ekpyong, has been trying to do in family court. And wait till I get in a video of those materials. This fucking psychotic, unhinged lawyer serving me 4 times, motion of contempt, the same fucking forms, never signed. This is crap, what they did to me. You know, the games they're playing with me with these endorsements. They didn't even, James Marnett, they didn't have the decency to look at my application and see all the fucking damages from that illegal eviction. He would have saw the email that John David Ekpyong instructed his client to evict me. These deputy judges are part-time. They're like a level 2, level 3, probably a level 3 court staff person. You've got a senior judge who is like the 5th or the 6th level, okay? They're taking instructions from these judges, these senior judges, okay? It's evident, okay? Imagine that. The assessment hearing, they just, they fucking railroaded me, and then now this is all on hold. It's been stayed, okay? I had all my materials for the family court to make a request for a change in that thing. They fucking would not let me, okay? This Kerry Rice, they would not let me. I'll show you all the emails. They would not give me the audio recordings, okay, from that vexatious litigant application, which was absolutely fucking bullshit. They forced me to go do that on an application left at my door. No. The Minister of Justice is ignoring me. The Attorney General of Ontario is ignoring me, okay? The Canadian Judicial Council has dismissed my complaints. I'm escalating this further and further that you cannot get anywhere. This is the only remedy, is to go public. Share your experiences. Have a conversation, about what you went through. And don't lie. Don't mislead. Have exhibits. Have evidence. You know what I mean? Don't threaten anybody. Share your experience, and that's what I'm doing. And but what I went through, how do you not get upset, and speak your mind, And this, if this has happened to me, how many other Canadians out there is this happening to? Big problem of a lot of this is the Liberal government. The Liberals in charge. Look at the damage they're causing to this province and this country. Look at the judges they're appointing. Okay? We have a big problem here. I've recently seen payout, the government paying out all the city of Waterloo, the city of Toronto, the amount of fucking money that these public services are getting, you would not believe. Billions and billions and billions of dollars are getting pumped into these systems for these individuals to get comfortable and abuse the public like they've been abusing me. Yeah. I was the first vexatious litigant up in Kitchener-Waterloo, which is fucking absolutely bullshit, over an application left at my door. A lawyer who never confirmed his motions, doing this bullshit that he did. I wouldn't be surprised that they're going to try to do this whole be shit on me. The way they manipulate and the way they back each other. No, this ain't right. This ain't right. Who am I supposed to reach out to? The Chief Justice of Canada, the Chief Justice of Ontario. But if all these people are doing this to me, I don't trust reaching out to them. Because there's a thing I noticed too that I haven't mentioned. Usually they get the junior level people to like do all their dirty work, and then you've got their superior that's saying, nope, this person double checked everything, and nope, they made the right decision, which is fucking bullshit. You try to appeal it, you can't. You try to question it, argue it, you can't. And that's what they've done to me. These deputy crown attorneys protecting these these assistant crown attorneys. Happened to me in Barrie. Frank Giordano, Paul Tate, they did the same thing. It's happened to me in Kitchener-Waterloo. Armin Sethi and what's his name? Wilson Lim. I've just reached out to, I was told it's the regional crown attorney. Alana, I don't know the pronunciation of her last name, F-P, telling me same thing. Oh, Armin looked into all this and no, she made the right decision. No, she didn't. She had it right in front of her that my ex submitted a fraudulent home insurance bill over $5,000. She got paid $10,000 that funded this bogus family court case. She had it in front of her. I broke a $500 door in front of the Waterloo Region Police. This deputy crown attorney doesn't want to look into it. She dropped the charges. What about John David Ekping-Young's $160,000 fraudulent court cost bill? What about his $55,000 fraudulent divisional court appeal? What about his $55,000 fraudulent vexatious litigant court cost? All that fucking bullshit where he admitted on affidavit he paid 1/10 of that. And she did a thorough investigation. This is my life. This is what I'm going through. And I'm sharing this shit with everybody. 'Cause I'm fed up and there's no accountability. And there needs to be accountability. And you know what? There will be accountability. That's not a threat. That is something I'm going to be working on. And how do I do that? By going public, by sharing these videos with you guys. And trust me, they're not easy doing. Sharing my life like this, like an open book, being transparent, being honest. Unlike these public servants who have been caught red-handed, abusing their powers, need to be investigated. Some of them removed from the bench. Some of these, And then we wonder why there's lawsuits against the Attorney General when you got shit like this happening, right? Okay, I'm going to end the video right there. I know I'm going on a rant right now. I'm pretty frustrated. Just thank you guys for watching my channel. Thank you guys for supporting my channel. And I'm looking forward to getting into some more topics other than this courtroom corruption, this police brutality stuff. I can't wait to get into, the shit that Justin Trudeau did to this country, the lockdowns, the vaccines, the immigration, the interest rates, the crime, all these fuckers getting bail, committing murder, first degree, second degree, fucking manslaughters, getting bail. You know what I mean? These new Canadians getting slaps on the wrist. We got so much to talk about. And we need to talk about it. So thank you guys for watching this video. This has been a video on my Kitchener-Waterloo Small Claims Court disaster. And I thank you guys for watching my channel. Let's talk about it. And thank you guys.